Hello and welcome to BYJU'S Exam Prep IAS. So as part of your weekly current affairs series, today we are going to discuss a very important treaty called the Treaty of the High Seas, also sometimes called Biodiversity Beyond National Jurisdiction Treaty. So Biodiversity Beyond National Jurisdiction Treaty, or what we call as BBNJ Treaty. So this treaty is generally important because it gives us an opportunity to understand the world history part of it, the environment part of it, and the international relations. It always gives us an opportunity to revise an important concept, which is the UNCLOS. So before we begin, I would request you to subscribe to the channel, and if you find this video useful, do like it. So let's talk about why are we discussing this treaty. So recently we had the 4th edition of an important intergovernmental conference, but as we speak it is also going on, is actually about a very important treaty which deals with biodiversity beyond national jurisdiction. So what we are going to understand in this video is to understand what do you mean by high seas, national jurisdiction, and why do we need this treaty generally. So what they're trying to devise is an international legally binding instrument for marine biodiversity beyond national jurisdiction, BBNJ, and we're going to call it BBNJ, or we'll call it the High Seas Treaty. And it is about two very important words. First, conservation, and second is sustainable use of marine biodiversity. So the treaty itself is dealing with two things. First, protection, which is conservation. At the same time, it is also talking about the sustainable use of marine biodiversity, because at the end of the day, the international waters are very important source of fish and marine biodiversity. The point is, this whole instrument is being developed within what we call as the UNCLOS, or United Nations Convention on Law of the Sea, and I'll call it UNCLOS from here on forward. The point is, UNCLOS itself is important, is at its own history, which links up with world history. And over and above that, there's an environmental issue here and something related to international relations. So it's at the intersection of three topics. That is why it becomes very, very important. So the point is, why do we need the BBNJ treaty? Let's try to understand that first. When we talk about international waters, which is, and I'm going to use this term but explain it later, which is the exclusive economic zone, EEZ, is called international waters, meaning 200 nautical miles off the coast of any country. After that, 201st nautical mile technically becomes international waters. Now, international waters, what the IUCN and what the UNCLOS argues is that areas beyond national jurisdiction actually account for close to 95% of the ocean. Meaning only 5% of the ocean is actually under the sovereignty of some country. 95% of the ocean is actually under international waters. Over and above that, what we see is the IUCN argues that if we account for this area vis-a-vis the Earth's surface, nearly half of the Earth's surface is under international waters, which means that international waters does not have a sovereign power or a state controlling its exploitation, exploration, or anything. So it is very important that this lacuna or this gap is not exploited by the world powers. So the current regime which deals with this believes that area beyond national jurisdiction, and we're going to expand on this, is owned by none but by all. So technically, over-exploitation can be done because there is no oversight. And that is what is actually happening, which is over-utilization of fishery resources. And there is now a fear that we are inducing extinction in these international waters. Therefore, UNCLOS needed to expand and regulate it. But let's try to understand what do we mean by international waters and what has been the general regime in this regard. So, what was the pre-UNCLOS regime, which is pre-1994, because 1994 UNCLOS is going to come into force. So, what is the pre-UNCLOS regime? Very simply, it was based on a 17th century concept of what is called freedom of the seas. What do you mean by this? It meant that the jurisdiction, see, every country has a sovereign right over its resources. So India can exploit any of the resources which is within its boundaries. However, when the land boundary ends, then how do we calculate how much of the sea or the ocean is part of our sovereign right? This was dealt with a very old concept of the freedom of the seas concept, which argued that the sovereign right generally was only 3 nautical miles or 5.6 kilometers across the baseline of the coastline, meaning 5.6 kilometers from the coastline, it was considered territorial waters, and you could do anything with regards to exploitation, freedom of passage, or when it comes to exploration within these 5.6 kilometers or 3 nautical miles. And that was the generic concept which had existed since the 1800s, till 1994. For throughout the colonial period, what we see is that the concept is very vague, and it is based on a very small section of the ocean or the sea recognized as national waters. So the concept is very, very simple, that historically there was a major gap in this area because firstly there's no enforcement agency, and this is just based on a gentleman's agreement that yes, everybody's national borders, which is the territorial line, thereafter 3 nautical miles, we will accept as the national, what is called territorial water. Now this is a very important point. Why? Because this creates the opportunity for the countries to exploit this gap. So what happened is, by the turn of the century, by 1900s, what we see is that the different countries, because it is important to have fisheries, the what is called polymetallic nodules which are found at the base of the ocean, these specific type of marine resources which are available, people and the countries wanted to expand this territorial water concept. And the country which took initiative in this was actually the US. Because what the US did under President Harry S. Truman in 1945 itself, by the end of the Second World War, what he argued was that our whole continental shelf, which is a natural formation, is our territorial water. So as a bipolar power, as the second most important power vis-a-vis USSR, it said that we will just expand our territorial waters, and territorial waters goes till continental shelf. Now this is an important point. Why? Because there is nobody to enforce anything. The UN regime is now coming up, but the point is US became the foremost power which exploited the gap within jurisdictional power and legal sector when it comes to mineral resources, protection of fish stocks, supply of resources, and pollution in this area. After the US, what happened was other South American countries such as Chile, Peru, Ecuador, what they did is between 46 and 50, they slowly but surely started to extend their concept of territorial waters 370 kilometers into the sea, which is technically 150-200 times more than what is allowed in the freedom of seas concept. So technically there is no real authority which can enforce this. So now there's an arbitrary extension of national jurisdiction, which is the right to exploit and to have safe passage in this area. So what happens is that by 1950s, 60s, the need for this became very, very apparent. So till this point, what we've done is we've tried to understand what is the BBNJ treaty, which is about biodiversity conservation and sustainable use. Over and above that, we have tried to understand how this concept has developed and why this concept is needed, because there is over-exploitation of resources till this point, until the UNCLOS is not coming up with this treaty and ratifying it, and it's a legally binding treaty. There is a lot of over-exploitation in international waters. And what we're trying to understand is, till this point, the history of how people, and technically people or countries, have actually dealt with this issue. Meaning, countries have used this arbitrary extension concept as there is no real authority which can enforce anything. Therefore, the arbitrary extension of national jurisdiction, their right to exploit, 370 kilometers, vis-a-vis it would be 5.6 kilometers. This led to a need to introduce something new. And that is the concept wherein UNCLOS comes in. And UNCLOS needed to first define national jurisdiction only. We are not right now dealing with the BBNJ. We are not dealing with the biodiversity beyond national jurisdiction. We are dealing with the need for the UNCLOS. The need for the UNCLOS comes in because there is arbitrary definition and extension of what we call as national jurisdiction. So, in 1967, in the UN, there was a very big issue of territorial waters, and now countries started to conflict over what is the definition of territorial waters and what is the jurisdiction generally. This created the need for an organization to look after the law of the sea. As there is law of the land, there needed to be a law of the sea. So, the United Nations Conference on Law of the Sea was established. It had two very important meetings, and at the third meeting of the same conference, the United Nations Conference on Law of the Sea, the UNCLOS was born, which is called the United Nations Convention on Law of the Sea. And it was this jurisdictional debate between 1973 and 82 which led to the solidification of the constitution of the UNCLOS. And it was put up for signature in 1982 and became effective in 1994 with, by 2016, 167 countries and the EU part of it. It is one of the most comprehensive treaties, and unlike the UN, has worked quite well till this point, but the gap has now been identified. So what does the UNCLOS talk about, and what is the regime? And this is how we revise the static portion of a current affairs. The current affairs part is only the BBNJ treaty. We are trying to understand the history, and now we are going to talk about how do they actually divide the concept of territorial waters. And this is the interesting part. See, what we see is that the UNCLOS said that we cannot just define national jurisdiction arbitrarily. We need to do it in a process in which there's a systematic zonal concept. So what it did was it introduced 5 zones with certain sovereignty rights and exploitation rights. So it said internal waters, territorial sea, contiguous zone, exclusive economic zone, the word I used, and the high seas. We are technically dealing with the high seas, but we also have to understand what is this concept related to internal waters, territorial sea, contiguous zone, and EEZ. Now, what it argued was that where the land or the land border of a country ends before the continental shelf begins, we take it as a baseline. And anything which is before this baseline is internal waters. In internal waters, there is full sovereignty of the country when it comes to exploitation, navigation, and nothing can be dictated by any other country or even an international organization. With this baseline, now what the UNCLOS said was that for the first 12 nautical miles, and for the first 12 nautical miles, we call it the territorial sea and the national airspace, meaning the airspace over the first 12 nautical miles is called national airspace, and this area, which is called the territorial sea, the country has complete control and sovereignty and right over this area. It can stop any ship, it can stop any safe passage, it can exploit anything related to topsoil, even the bed. So territorial sea is actually an extension of the border itself till this point, meaning the land border is now 12 nautical miles inside the ocean. Now comes what is called the contiguous zone, which is the next 12 nautical miles, or from the baseline 24 nautical miles. In this, the right to exploitation and the use generally of the natural resources is there, but the national airspace concept goes away. Meaning after 12 nautical miles, the space part, the airspace in which the flights can take off and take into, is now international airspace. So the generic concept of territorial sea is extended, but the airspace concept is removed. And then what the UNCLOS argues is that from the baseline till 200 nautical miles into the ocean or sea, we call it the exclusive economic zone or EEZ. EEZ is important because here the country cannot stop the ships for peaceful purposes, but it has complete control over the economic resources, fisheries, the mineral resources, and even the water-powered electricity generation rights, meaning it can use anything till 200 nautical miles as a concept of its extension of economic right. It is international space, sure. The sovereignty is surely but surely going away. Slowly it is going away, and it is now going into what is called the high seas, meaning after 200 nautical miles, it becomes high seas or what we call as international waters. But till 200 nautical miles, the sovereign right remains, but in a diminished way, but the economic right remains in a fully asserted way. And this is why it's called the exclusive economic zone. Till contiguous zone and territorial sea, it is generally the sovereign power and the right of the country is there. But once you come to the EEZ area, the sovereign power starts to go away, the right to exploit goes away as a sovereign power, but the economic rights remain. And what the BBNJ treaty deals with is not till here. They don't deal with the first 200 nautical miles because here the right of the states, the countries, are very well defined. The problem was that the high seas was not defined, or the exploitation of marine biodiversity has not been defined in the high sea sector. So first you understand this, I have everything written in the PPT also. The point is, first 12 nautical miles is what is called the territorial water. It is technically an extension of the land border itself. Then the next 12 nautical miles, which is the contiguous zone, or the first 24 nautical miles, out of which 12 and 12, this 12 in this national airspace concept goes away, but it is technically an extension of the territorial sea concept. And after that, from the baseline to 200 nautical miles, remember here it is counted 12, and then the 200 is counted from the baseline. Remember this. They can play with the question in regards to the measurement. And the point is very, very simple, is that this exclusive economic zone, the sovereign power when it related to airspace or the movement of ships is removed, but the economic right is protected. So let's try to understand and read it out so that it becomes a form of reinforcement in your mind. So what is territorial waters? The coastal states have sovereignty and jurisdiction on territorial sea. These rights extend not only on the surface, but also the seabed, subsoil, and even airspace. So this zone, even the airspace is considered national airspace. You have, if you need to enter into this area, you need the permission of the Government of India and specifically the Indian Air Force to enter it, because it is Indian airspace. Now, what is contiguous zone? Contiguous zone, the coastal state has the right to both prevent and punish when it comes to infringement by ships related to fiscal, immigration, sanitary and customary laws. So in this zone, if there's a ship which is technically not adhering to the fiscal or the custom laws or to the laws related to immigration, then the government can intervene. And this is technically an extension of the territorial sea, but the ship passage, there is a lot of rules and regulations which have been brought in. Unlike the territorial sea, the contiguous zone gives jurisdiction to a state on the ocean surface and floor. It does not provide airspace rights. So a major difference would be, if you are in the territorial waters of a country, you can be stopped for any purpose. When you are in the contiguous zone of a country, you can only be stopped if you're infringing any law. And the airspace concept is, this is national airspace, this is now fully international airspace. In this area, you can be stopped for any purpose because it is technically the water border of that country. And in this space, you can be stopped if you are infringing on the rights or on the laws which are of the sea and of the land of the concept of fiscal, economic, and even sanitary. Meaning if you have something contagious, if you have a toxin on board, if you have nuclear waste on the ship, you are technically not allowed to enter into the contiguous zone because that would be an infringement of the sanitary related laws of the country. Now comes EEZ, which is an interesting one. Sovereign rights for the purpose of exploring, exploiting, conserving, managing natural resources, whether living or non-living, on the seabed and subsoil. So, full economic exploitation rights are given. But the rights to carry out activities like production of energy from water, currents and winds is also given. However, it does not give a coastal state the right to prohibit or limit freedom of navigation or overflight. Meaning, if they are even infringing any laws in the EEZ, you cannot stop the ship itself. So it's a very complicated system, but very, very well defined, that the first national space or national airspace or territorial sea is technically an extension of the border itself. Then comes the contiguous zone, wherein the airspace becomes international airspace, but in this you can only stop a ship if it is infringing upon the general problems of the law, and that is the sanitary, economic, fiscal, or anything related to which is a threat to national security also. And in the EEZ, you can exploit as much as you want, but you cannot stop a ship. And after this point, it is high seas, which we have to deal with and which we are more concerned with. So I hope till this point you are getting the general zones and the general measurements. Now, what does high seas mean, or what we call as beyond national jurisdiction, or what is called international waters? The high seas are open to all states, whether coastal or landlocked. So any country, even Bhutan can use it for in the Bay of Bengal. The point is that this is not owned by anybody and everybody has a right here. Now, the high sea shall be reserved for peaceful purposes, meaning you can't technically be fighting a war in international waters, but the whole politics in the Indian Ocean right now is about controlling international waters when it comes to China, when it comes to India, when it comes to how the US is acting in this area. So that is technically controlling international waters. Peaceful purposes is with a quotation because everything is about controlling the naval passages. Now, no state may validly purport to subject any part of the high seas to its sovereignty. So no state can allegedly allege that we are the sovereign power in this area. So it cannot say that this is my zone. So no country can claim that it is actually the area of that country. On the other hand, every state, whether coastal or landlocked, has a right to sail ships flying its flag on the high seas. So technically, high sea or international waters or beyond national jurisdiction is a very generic term which is used for anything which is beyond the EEZ, and everybody has equal right there. And the BBNJ treaty tries to actually now regulate exploitation beyond the EEZ area. See, because till EEZ, everybody has a very good understanding of how exploitation needs to happen, how it will happen. The problem starts when there is no jurisdiction. Beyond national jurisdiction, any country can do anything, meaning like Russia, what it is doing in the Arctic Ocean or the Arctic Sea. Over and above that, what China is doing in the Indian Ocean. The point is, there are certain pockets in which you find more fishes, and there is overexploitation. We are seeing that toxic waste is being dumped into the sea because there is no real regulation for that. So what the BBNJ treaty did and is doing is trying to address this issue. So when did this issue begin? And when did everybody identify that the UNCLOS was not working? And that comes from the 2012 UN Conference on Sustainable Development, or what we call as Rio Plus 20. And I'll give you a quotation from there which technically talks about this alarming situation in half of the Earth's surface, or 95% of the ocean water. It says that the states committed themselves to address on an urgent basis the issue of conservation and sustainable use of marine biodiversity of the areas beyond national jurisdiction, including by taking a decision on the development of an international instrument under the United Nations Convention on Law of the Sea. So under UNCLOS, they wanted to introduce a legally binding instrument which could talk about beyond national jurisdiction. This topic is important because it is dealing with three important things. First, national sovereignty. It is also dealing with the concept of UNCLOS. It is dealing with the historicity of how these seas were governed. And it is also dealing with environmental issues related to overexploitation of marine biodiversity. So over and above this, when this thing was identified, the following 2 years, there was a preparatory committee which was established, and the UN finally passed a resolution 72-249, don't have to remember it, 72/249, in December of 2017, that we will convene an intergovernmental conference to develop this instrument which we call as the BBNJ. And the meeting which is going on as we speak is technically not the first one. So the first 3 sessions of this intergovernmental committee has already happened, or convention has already happened. In New York, 4th to 17th September 2018, then in March, April 2019, then in August of 2019, and after the COVID pandemic, we are seeing that this again conference has met as we speak for the next 2 days in New York. The point is, this is a very, very important treaty and is a mains related topic in the sense that the concept of international waters now becomes very, very important. In the prelims, it can appear as a question related to the EEZ concept or UNCLOS itself, and the history of UNCLOS itself becomes important. But in a mains question, what you will see is that there will be a very interesting way in which they will ask you that why is there a need for BBNJ? So, what are the principles on which BBNJ is being developed? And this is the last point which I want to make. The point is, it's about conservation. But the problem is, you can't say that whole of international waters cannot be exploited, because at the end of the day, we need the fishes. We need the fishes in the dietary pattern of the world. So there needs to be a sustainable exploitation rather than just saying or banning everything. So the first and the most important principle which is being used here is the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, in particular, together or as a whole, marine genetic resources, including questions on sharing of benefits. So what it's saying is that we need to conserve the genetic diversity, which would mean that the species need to be conserved in the larger context in sharing the benefits. So when it comes to sharing the benefits related to fishes or fisheries, there needs to be an understanding, but we should not overexploit one fish resource so much that it becomes extinct. So it's about identification, it's about conservation, and it is also about sharing the benefits. This is a very important point, because now in biodiversity conventions, this is a thumb rule, there's now this new word which has come in, which is accessibility and shared benefits. So the shared benefits part is very, very important, because you cannot ban and say, no, you cannot fish anything here. Then comes area-based management tools, including marine protected areas. So what it's saying that we will identify marine protected areas or areas which need to be protected like national parks on land, you need marine protection zones. And we will also have area-based management tools, meaning we will not have one whole system for the whole international waters. Every ocean and every sea is different, and we will have a management tool separately for separate oceans and seas. This is important. Why? Because, for example, the Atlantic Ocean would be more exploited than the Pacific Ocean. So therefore, a management tool in such a big ocean like Pacific would not work in the Atlantic. The same would not be true for the Atlantic in the Pacific. So area-based management is very, very important. Then we will do an environmental impact assessment of all the ongoing projects when it comes to how the countries are exploiting and undercutting the UNCLOS regime. And this would be very important because this would give us an idea of how much damage has already happened, because we are in the dark right now. Last, capacity building and the transfer of marine technology. Meaning it should not be that US has a very good technology to understand the seabed, but we don't have it, or we have it and Pakistan does not have it. If we have it, China does not have it. The point is, marine technology needs to be shared so that the technologically every country is par in understanding what is after the exclusive economic zone and in the international waters. This is a very important point because there is a major imbalance in technological aspect. They can identify polymetallic nodules just by taking ships into the water. But we would need some form of excavating instrument. Russia at this point of time has the capacity to identify petroleum deposits in the Arctic Ocean just by having sonar-based technology identifying certain types of rocks. That should be available to everybody. The point is very, very simple, that this treaty is about curbing or finding a solution to an issue which we were never able to identify. So before I end this session, I would like to give you a small summary. What have we done here? We've tried to understand what is international waters. We have tried to understand that what is the UNCLOS regime from Territorial Sea to the context of contiguous zone to the exclusive economic zone, EEZ. Over and above that, we've tried to understand what comes beyond the EEZ, which is the international waters. And we tried to understand how the international waters is a major gap when it comes to the UNCLOS regime, because it talks about the first 200 nautical miles very well, but after that it doesn't. And that has led to a gap which has been exploited by developed and developing countries by over-exploiting the fishery resources, mineral resources, and this exploitation is happening as we speak. So the BBNJ treaty is an answer by the UNCLOS to an issue which was identified in 1967 itself, and throughout that period they have been asking for certain type of legally binding instrument. And since the BBNJ concept has been introduced, there's a lot of hope that this legally binding treaty will be ratified by everybody. But the point is, for you, why is it relevant? Because in UPSC you should read what is important. So why is it important? It is important because it is dealing with three institutions which now need to be revised before the exam. First, UNCLOS. What is the UNCLOS? What is the history of the UNCLOS? Wherein comes the world history part. Second, what was there before the UNCLOS? The freedom of seas concept. Third, the concept of marine biodiversity becomes important because now this word has come into vogue and is now in the news. And last but not the least is, once you clear prelims, this topic becomes important because they're talking about a concept of biodiversity with respect to international relations and world history, which is biodiversity beyond borders. And beyond borders or beyond national jurisdiction creates a new type of understanding. So before I end this session, firstly, I would like to thank you for your patience. If you liked this video, do like it. You can always tell us what you want to deal with in these explained sessions. You can write it in the comment section. Tell us what you want us to deal with. Last but not the least is, please, these treaties are very, very important in the larger context. You need to identify them. These are these obscure treaties which come in the prelims examination, and because it has been there for a very long time now, it can appear in the exam. With this, thank you so much. Do subscribe to our channel. I will see you in the next video. Bye-bye.